Hello and welcome to this Federalist Society webinar. This afternoon, Wednesday, April 24th, we have a litigation update on climate lawsuits and their status in the U.S. Supreme Court. My name is Ryan Lacey, and I'm an Associate Director for the In-House Counsel Network at the Federalist Society. As always, please note that all expressions or opinions are those of our expert on today's call. Today, we're fortunate to have an excellent speaker in Theodora Boutros, whom I'll introduce very briefly. Ted is a partner in the Los Angeles and DC offices of Gibson, Dunn & Crutcher, and is co-chair of the firm's Appellate and Constitutional Law Group, its Crisis Management Group, and the Transnational Litigation and Foreign Judgments Group. He is a member of the firm's Executive and Management Committees. He received his law degree from the University of San Diego and his bachelor's from Arizona State University. After our speaker gives his opening remarks, we'll turn to you, the audience, for questions. If you have a question, please enter it into the Q&A feature at the bottom of your screen, and we will handle your questions as we can towards the end of this afternoon's program. With that, thank you for being with us today. Ted, the floor is yours.
Thanks so much, Ryan. It's great to be with you to talk about these important issues. As you mentioned, I've been handling these climate change cases, representing Chevron in the cases, but also playing a leading role in arguing the key motions in legal questions. And we now have a cert petition pending in the Supreme Court. I'm going to go into detail on that in a second, but I thought it would be helpful to set the stage a bit with a little of the history behind these climate change cases and how we got to where we are. The climate change tort movement is not new. It really started almost 20 years ago, and plaintiffs' lawyers for states and municipalities and some private individuals started bringing cases in federal court arguing that there should be a federal common law tort claim for climate change damages that cascade allegedly from the greenhouse gas emissions. One of the first cases was the General Motors case filed in the Northern District of California, a case I handled back in the early 2000s. So I've been at this a while. And it was against a case brought by the state of California against all the major automakers. And the district court there rejected the claims, finding that they were political questions, they were unmanageable, they raised questions of policy, seeking to hold the automakers liable for climate change and the effects of climate change based on greenhouse gas emissions around the world. The court said that's just not something the courts should be tackling, nor can they in any rational way. There was the Kivalina case, which was percolating around the same time against the energy companies, including many of the companies who are now being sued in this latest round of litigation. Again, in federal court, the district court and the Ninth Circuit rejected the claims on various grounds, including political question and including the grounds that federal common law could not be applied here. And it relied on the AEP case, American Electric Power case, from the Supreme Court, which was the case against the 5 power plants brought by a number of states and municipalities. In the Supreme Court, Justice Ginsburg wrote for a unanimous court that this was an area of federal law, but it's an area of federal law that Congress, via the Clean Air Act, has given the EPA authority over. And the court emphatically said that judges, there they were talking about federal judges, but focused on the fact that judges can't engage in these important policy questions that include science questions, complex technological questions, the fact that one judge would be basically determining how high emissions should be, how much oil and gas should be used, how much power should be generated. And the court said these are issues of complex balancing and international and national issues of policy, and they're committed to the EPA under the Clean Air Act and rejected the claims in that case. And then in Kivalina, they were seeking an injunction. In Kivalina, they sought damages. The Ninth Circuit came out the same way. And so once the AEP was decided, case was decided in 2011, it took quite a while for the plaintiffs' bar to come up with a new theory. They but they did. They had a meeting in La Jolla, California, a nice locale, where they came up with the idea of filing in state court under state law, making state law claims of nuisance, trespass, negligence, failure to warn, and the like. But it took them a while. I think it was about 7 or 8 years before they launched this effort, but they launched it with a vengeance. And so we saw the first few cases filed in California, and then it spread like wildfire through the country with cases filed around the country. We're now up to, I think, 34 cases brought by cities, counties, and states, from Hoboken to San Francisco to New York City, which I'll come back to in a second. So it's a barrage of lawsuits, all seeking to impose damages for the same thing, all seeking to impose damages for injuries allegedly caused by the effects of interstate and international greenhouse gas emissions on the global climate. So it's a truly global case. And we originally tried to remove the cases to federal court on the theory that this is an area of exclusive federal domain when you're talking about interstate and international pollution of water and gas. And that's what the EPA has called greenhouse gas emissions. And the courts ultimately rejected those efforts. There's still a couple removal issues percolating along, but right now we're back in state court around the country, litigating the merits of these issues. And it's refreshing to get to the merits, because every time a court in the federal system has looked at these issues, they have, from one angle or another, state or federal, they've rejected these claims. There's one outlier, and that is the Hawaii Supreme Court and Hawaii Trial Court. So that's where we are. On the merits, the Second Circuit in the City of New York case several years ago, in one of the early cases filed in this round of litigation, filed in federal court under diversity jurisdiction. So we didn't have the removal issues. In the Second Circuit, we in the district court and in the Second Circuit, we prevailed. The district court, Judge Keenan, and the Second Circuit both held that even though the claims that New York brought were labeled under state law, nuisance, trespass, and the like, federal law governs the area of interstate and international air and water pollution. So the federal law was the only potential source for their claim. The court noted that the Supreme Court, in a virtually unbroken string of cases, had held that where we're talking about air and water in their interstate and ambient state, that's an area only that only federal law can govern. There's a uniquely federal interest. There's a series of cases, Milwaukee 1, Milwaukee 2. There's where the Wallet case from, which is a preemption case under the Clean Water Act, where the Supreme Court has said over and over again, this is a unique area because, for example, air is traveling across state boundaries. And I don't think the court, until AEP, envisioned that someone would bring a case seeking damages for air and around the globe, and alleged emissions around the globe, mixing and heating the atmosphere and then causing damage back in their particular jurisdiction. But that's what these cases are. The Second Circuit found that those kinds of claims, if there's a source of law for that kind of claim, it's federal. And the Clean Air Act had displaced federal common law claims. That's what the Supreme Court held in AEP. And then the court also said that the international focus of the claims made the claims still subject to common law, if anything, but that federal courts could not, consistent with the separation of powers, start making tort claims that would have an impact on foreign policy, foreign relations, and foreign countries. And so the court rejected those claims squarely in the City of New York. State law cannot be used, the court held. And let me stop there to explain the substance of the claims, because it's really interesting how they've evolved. In the early litigation that I mentioned, the federal litigation, the focus was first on the emitters, so the power plants in the Northeast. Then when those claims were rejected, there was another wave of cases. I mentioned the automakers. So they were being sued because they manufactured vehicles that people would buy and then put gasoline in them and then consume the gasoline, creating emissions around the country and around the world, heating the atmosphere and then causing damage back in California. The energy companies, the oil and gas companies, were sued under a similar theory that they sold this product, it caused this harm, there were emissions that flowed from it. When we went into the removal battle, the plaintiffs, I think, knew that the more they focused on production and straight up the activities that generated the emissions, shifted their theory to say, oh, we're not trying to regulate emissions. We're only focusing on alleged misrepresentation and deceit and marketing oil and gas and failure to warn. We still don't know exactly what they mean by failure to warn, but the closest I can tell is they think there should be a label on the gas pump that tells a consumer consuming this gas will contribute to climate change and climate change will have these effects. It's never been very clear, but they've steadily narrowed down the liability basis of their theme to focus on this notion that oil and gas companies knew for decades that the consumption of fossil fuels can contribute to climate change and is the main driver, in their words, of climate change. I'm accepting all their allegations is true for this webinar as if it's a motion to dismiss hearing, since we've been having a lot of those. But and that the companies didn't warn the public or governments or other countries or people around the world. And at the same time, they committed the cardinal sin of engaging in free speech by marketing their products, trying to persuade people to buy them. And also, more importantly, their complaints are filled with allegations, and the complaints are basically all the same at this point. The claim is that there were misstatements and false depictions of climate change and its effects in public, meant to influence the public and in turn to derail regulation, to derail treaties, and to stop legislation and public policy actions that would have curtailed consumption of fossil fuels and curtailed climate change. So it raises those are the complaints. They never really, for example, with Chevron, they never point to a single false statement that Chevron has made anywhere. It's all very generic, but it raises significant First Amendment issues because the Noor-Pennington Doctrine, for example, provides absolute protection for public speech meant to influence Congress or policymakers. We haven't quite got to a real First Amendment ruling in the case, but we're starting to really delve into the merits of those issues in the motions we're arguing. But the theory is, I think it's outlandish that under state law, whatever the labels, they have nuisance, trespass, whoever heard of trespass by speech, no case has ever held it. The state law cases they're relying on don't really come close to recognizing the kind of torts they're seeking. But the theory is that these companies, plus API, the American Petroleum Institute, which was the main lobbying arm for the industry, increased the levels of consumption around the United States and around the globe based on their speech or based on their failure to warn around the United States and around the world to levels that, for example, New Jersey, where we just had arguments on the motions to dismiss in Trenton, beyond levels of emissions that New Jersey thinks would be reasonable. And so it really is a classic example of New Jersey seeking to apply its tort law on failure to warn, on the trespass and nuisance in a way that would, first of all, regulate emissions around the globe, because their theory is that this speech has increased emissions to unreasonable levels. And they're saying that the failure to warn law, which we don't think gives them a cause of action under New Jersey law, should be interpreted to mean that New Jersey can basically control and regulate the speech of these companies around the globe, require them to give warnings around the United States and around the globe. So that's their theory. The only case that has come close to recognizing that that's a viable role for state courts is the Hawaii Supreme Court. It rejected our arguments. It squarely rejected the City of New York case. It said this is just a case about misrepresentation and deceit. It's not about emissions. It said that on the one hand, but then in the next breath, it noted that the damages that Honolulu is seeking is based on global emissions and then their effect on the atmosphere and then the effects of climate change on the Honolulu and the citizens of Hawaii. Their claims there, like City of New York, claimed deceit and deception increased emissions somehow, and that these companies should therefore be held liable for all the consequences of climate change that they say flowed to Hawaii and to Honolulu. And I should say, all these jurisdictions are massive consumers of the very products they're suing over, oil and gas and gasoline and fuel for jets. All those things are super important to Honolulu and to Hawaii. And it's the same thing with the others who are suing. They're significant participants in the activities that they say are creating a nuisance. And they're also entities that had full knowledge based on the science from the IPCC, the UN body of scientists who since 1990 have been putting out reports about climate change. The federal government has been announcing and dealing with climate change since the 60s. Lyndon Johnson made a proclamation. He had a science council that talked about the very dangers and risks that the plaintiffs say were being secretly withheld by the energy companies. But the Hawaii Supreme Court found that because it was a deception case and because the Clean Air Act had displaced federal common law, that meant there was room for state law, and therefore there could be state causes of action along the lines that I just mentioned. And it said it disagreed with the City of New York case, that the Second Circuit was wrong, that when the Second Circuit held state law doesn't spring back to life when the federal government passes a statute that regulates the very activities that the state cause of action and the federal common law cause of action would have targeted. And so the Second Circuit got it wrong. So we have a clear split between the Hawaii Supreme Court and the Second Circuit on these important issues. And just to pause there on the Clean Air Act, it's really, I think, crucial to our point here. And I think for all of you who want to look at these issues more closely, we're not arguing that individual states have no role in climate change and climate change regulation. And the Clean Air Act itself says states have a role. It's very clear, just like the Clean Water Act. The Clean Air Act says that the state should play a role in regulating and dealing with pollution and greenhouse gas emissions within their borders. So emissions that emanate, say, from Delaware. Delaware can seek to restrict emissions. It can impose stricter standards than the Clean Air Act under certain circumstances. Moreover, under the Clean Water Act and the Clean Air Act, the Supreme Court has indicated and courts have held that one state, say Delaware, could sue under New York law for emissions that are happening in New York and causing damage in Delaware. This is where the federalism principles come in, because the Second Circuit focused on the federalism issues. The Supreme Court in AEP and in Milwaukee 1 and Milwaukee 2 focused on federalism issues because, as I mentioned, when Hawaii seeks to impose obligations to warn and to restrict speech in every other state, it's intruding on the interests of those other states. We have 20 states, I believe, have filed an amicus brief in support of our cert petition, along with 9 other very compelling amicus briefs that are advocating cert. And there are real federalism issues. One of the cases we use for our merits argument, and it's in our cert petition, is the Franchise Board versus Hyatt, where Justice Thomas for the Supreme Court wrote a very, I think, helpful opinion for us, saying that the Constitution implicitly restricts the power of one state to do things to either to another state or to take actions that would intrude on the prerogatives of another state. We all know that when the states decided to band together into a federal system, they each gave up some power. And Hyatt said that's implicitly baked into our constitutional structure. The Supreme Court in AEP said that the basic scheme of the Constitution says that states really shouldn't be trying to regulate this international and interstate emissions and pollution. That's an area for federal governance, in the words of Justice Ginsburg. And that doesn't mean that there's a federal cause of action. It just means that if there's going to be a law or going to be a rule, it's uniquely federal and it has to emanate from the federal government. So we have this split. It's very clean. In our cert petition, we argue that now is the time for the Supreme Court to weigh in, because there are more than 30 of these cases that have been filed, up and down the United States, across the United States, in Hawaii. It's this sort of chaotic situation that the Supreme Court has warned of. I mentioned the Wallet case, which was a Clean Water Act nuisance case, and the Supreme Court said that one state can't apply its own law to pollution coming in from a different source state, because that could intrude on the source state's establishment of emission standards and the like. And the Supreme Court in Wallet and in many other cases, including BMW versus Gore, has said that civil damage awards, compensatory and punitive damages, have a regulatory effect. They are meant to change behavior. And here, the plaintiffs resist the notion, but it's absolutely clear that their lawsuits are meant to, even taking them at their word that it's about the speech and the marketing and the failure to warn, they are seeking to either stop speech or require speech around the United States and around the globe in order to reduce emissions levels that each of these municipalities under their own state law say are too high. And they're doing that in a way that intrudes on, say, the interests of the 20 states that filed an amicus brief in support of us. If North Dakota thinks there should be no warnings on oil and gas, which there aren't anywhere, if they think that production is important, that wouldn't matter. New Jersey's law would apply to require these companies to give warnings, to change their speech in those jurisdictions like North Dakota. So it's a real graphic example of where state law cannot be used. And the Supreme Court, in cases that we cite, like Texas Industries and others in the pollution cases, make this very point. It's not so much that federal common law creates the cause of action. It's that our constitutional structure says that state law just cannot be used to seek damages based on the same activities over and over again, and that are international and interstate in nature. So we are asking the Supreme Court to take these cases. They are this case, the Honolulu case, before there are years and years and decades of litigation on these issues. And now's the perfect time. There's a conflict. The issues are clearly important. The lawsuits flout and contradict federal policy, federal energy policy. The Biden administration has been very strong, encouraging production. We have to, for our national security needs, for our economy, to live our daily lives, we need to keep producing energy while policies are developed to address climate change. It's an important issue, but it's not something that the courts are equipped to address. And so the cert petition says now is the time. We've got great amicus support. We believe the Hawaii Supreme Court decision is just a complete outlier. For those of you who are interested, you should check out the dissent from the Hawaii Supreme Court, sort of a gratuitous dissent, or actually it was a concurrence, so it was really gratuitous, that really attacked the US Supreme Court justices for supposedly not adhering to precedent, kind of just out of the blue. And the court in Hawaii rejected the personal jurisdiction arguments, but the concurrence focused on personal jurisdiction in a pretty ad hominem opinion. So we also point to the fact that maybe I'll just make a footnote here. It's really ironic because in these cases, the argument is these energy companies, private companies producing lawful products that are vital to modern life, supposedly had this secret knowledge and they were the only ones who knew this information. And if they had just been warning, then climate change would have been reduced, more statutes would have been passed. There's another set of lawsuits suing the federal government, making sort of the same arguments that the federal government had all this information and it didn't do enough. And so it really is I think a mess of novel tort theories, outlandish tort theories that intrude on interests of federalism and clash with the Clean Air Act, clash with the federal powers in this area. And we think it's really ripe for Supreme Court review. We also do have other cases percolating the system, but they're just farther back. The Delaware trial judge ruled in our favor several months ago and found that all the claims there that were based on damages allegedly flowing from out-of-state emissions and out-of-country emissions were dismissed, and the plaintiff there in Delaware is asking the Delaware Supreme Court to weigh in. So courts, that really focus on the merits and understand the extreme nature of these claims, the baselessness under state law. It's really pretty interesting because I've been enjoying arguing the state law pieces because the doctrine doesn't come close. In nuisance doctrine, for example, state courts have said we can't expand it beyond what we all think of as a nuisance. Someone's doing something on their property next door to me, they create a mess, it comes over and injures me. But they're trying to take that kind of tort and say misrepresentations around the world caused the atmosphere to warm, and we don't know where the emissions came from. They admit that. So it could be emissions in China, and the Supreme Court said this in AEP, that caused their damages, had no relationship to people in California consuming oil and gas products. They're trying to take the nuisance tort, which is a vague tort, and just create this monster, which the New Jersey Supreme Court called in a different circumstance, called a monster that would swallow all of tort law. Plus, it's clashing with federal constitutional interests and our constitutional structure in a way we think warrants Supreme Court review. So, Ryan, maybe I'll pause there and see if you'd like me to go into more detail, or if you've got a question. And I can talk about this all day, so I'm here for you. I know thankfully you've capped my time, but I'm ready.
Well, thank you very much for that very in-depth expose on the case and where it stands. I'm interested, and not asking you to get too speculative, but now that it's going up to the Supreme Court, how do you think this will shake out in arguments and decision, with the court being what it is now?
So it's really interesting. I think we've got Justice Kavanaugh dissented from the denial of cert on the federal jurisdiction questions, and the federal jurisdiction questions. There's sort of cross currents that I think led the court not to grant review there. The notion that, let state claims be dealt with in state court. We strongly believed that we had arising under jurisdiction, we had federal officer removal jurisdiction, but The courts just wouldn't go there, but Justice Kavanaugh was I think thought that it was he clearly thought it was an important issue the court should take. And I think if you look at the way our cert petition is drafted and the way we've pitched the matter, we've got a great team of lawyers from all different firms. Cannon is counsel of record on the cert petition, but it's just a great group of lawyers collaborating and really trying to just really lay this out in a way that undeniably cries out for review. And I think we've done that because I mentioned the Hyatt decision that Justice Thomas authored that talked about these very concepts of our constitutional structure. Our argument is the argument that respects federalism and the prerogatives of each state. Our argument is the one that respects the role of the federal government on these interstate and international issues. Our argument is consistent with what the Biden administration says, what the Obama administration said. In AEP, the Obama administration wrote a great amicus brief that said this would be insane. Everybody in the world would have a cause of action, but everyone in the world is participating in creating climate change. Federal courts can't be in this business. And so you see, really policymaker unanimity. You see the Biden administration, the Secretary of State calling for energy production to protect our country. So I think when you look at the doctrines we're relying on, the extraordinary nature of these cases, it really is a play for private lawyers funded by various foundations and the like, working with municipalities and states to seize control of federal energy policy and to change how we consume energy. And that interferes, as the Second Circuit said, as AEP says, with this complex balancing of our national security needs, economic needs, all those things, and to do it at the same time. So it's like 34 states would all be saying the same things, the same activities around the country and around the world. Those are torts under our law, and we think emissions should be at a different level. They deny that. They say, oh, we're not trying to control emissions. They clearly are, because the whole premise of their suit is stop debating climate change, oil companies, stop talking about solutions. You'll love this. They even say, the newest generation is to say, the company should be held liable because they recognize the issues of climate change and the dangers and the need to have cleaner energy, that should be a tort too. So you can't win with these plaintiffs' lawyers, but it really intrudes on both the federal government and then the separation of powers within the states, where it really should be Congress and the executive branch at the federal level. And then the mayors, instead of filing lawsuits, they really should be working to address climate change through policy means, and same with the state legislature. So I think we've really written a cert petition here that can appeal across the ideological and doctrinal approaches on the court now.
Understood. And a reminder to our audience that if you do have a question, you can enter it into the Q&A feature at the bottom of your screen, and I will get that question to Ted. Kind of following up on what you were saying about all these cases seem to be coming out of states and municipalities. And you mentioned that the Biden administration, has been pushing for energy production, but at the same time, the Biden administration has had a stake in talking about climate change and all that. Has there been a reaction from the administration to this case or cases like it?
There have been reports that the lawyers and the groups that have been the motivators and the participants in these lawsuits have been seeking to get the Biden administration to weigh in our cases. They've not succeeded. As I said, the federal government is subject to basically the same type of claims. There's this case called Juliana, for example, very similar claims, slightly different relief they were seeking. The Ninth Circuit rejected those claims once, and they're now, I think they're sort of being recast a bit. So the federal government is subject to the same types of claims that are being asserted here, and they've been making arguments that are very similar to ours. That this is, you're interfering with the federal government, and this is not the kind of thing that courts should be engaged in. And yes, the Biden administration has been focused on climate, but through legislation, through regulation, and we can debate how much regulation is needed, what type of statutes should be enacted and the like. But that's the way the system is supposed to function. And especially when we're talking about this area that the Supreme Court has said, state law, this is a quote, state law cannot be used because it's purely interstate and international. I keep challenging the plaintiffs' lawyers to say, oh, we're only talking about activities in the state and misstatements in the state that caused emissions to go up in the state. And they not only won't say that, they say the opposite. No, we're talking about global activity. We're talking about global emissions. And to me, that's game, set, match. You just can't have one state, let alone 34 states, all imposing damages for extraterritorial, out-of-state emissions and activities, the same ones, and they can't even identify which activities, by which companies, by which people, and in which country caused the emissions that caused their harm. And so it's really far-fetched to me, but that's why we think it's key for the Supreme Court in the United States to weigh in and stop the potential madness of all this happening for many, many years around the country. I feel like I'm on a like a tour of barnstorming minor league baseball team. We're traveling to so many different places, and it's really interesting. But it's really no way to deal with climate change. It's really counterproductive, I think, and not a solution.
Mm-hmm. Well, you mentioned that these emissions are global. So looking internationally, have arguments like this and cases like this been brought, talking about public nuisance, cases along these lines have been brought up in other countries, say like in the European Union? And what effect, if those cases do exist, could they have on, these companies like Chevron and Exxon? They're international companies. So regulation and court cases and decisions from other parts of the world could have effect on how they act in America.
Yeah, there have been cases, and they're in Europe, and they're percolating along there, and this international action can have an effect on U.S.-based companies and companies around the world, and so we're definitely closely watching those cases and also laws in other jurisdictions. It is a global problem, so we get that, but we can't. It will be very harmful to everyone if courts, international tribunals, and like seek to take action, which causes the same problems that I'm referencing with respect to state law claims here, seeking to essentially regulate what's happening in the United States and saying that you've got to stop doing what you're doing in the United States because it's having an effect in Europe. And so yeah, it's a very, very complicated mosaic, but courts and tribunals that adjudicate rights are not the place to go. And it's taking litigation concepts to pass the breaking point. And again, in AEP, it was remarkably forceful and unanimous opinion. Justice Ginsburg talked about these issues. These are really difficult, complex issues. Justice Alito in the National Review versus Mann defamation case said in a dissent from the denial of cert, the climate change is one of the if not the most, one of the most important issues and topics of discussion and debate in the world right now. And so we need free discussion, free debate. These suits are seeking to muzzle these companies that have a First Amendment right to speak under Citizens United and many other cases on issues of great public concern. And they're bringing these torts here, but you're seeing it in other countries, and so we can't have lawsuits and in courts and tribunals doing the same thing that we're complaining about here. So we're definitely keeping an eye on that.
Mhm. Looking at some of our audience questions, we have one that asks, in the Hawaii case, City and County of Honolulu versus Sunoco, there was a standing issue. To your point about the global nature of alleged harm, do you think that that's a challenge to other municipalities standing and to bring similar lawsuits?
Well, there really is, with standing and jurisdictional issues that in federal court, well, there would have been even better arguments once we got to that. But I think it's very hard. There was a personal jurisdiction issue there too, and they're very similar. They're closely related in the sense that if Honolulu can't point to anything that an oil company did in Honolulu or in Hawaii that caused concrete, directly traceable injury, there's a standing problem in the case, and they can't do that. And there's also there are personal jurisdiction issues that I mentioned in these cases. So yes, these lawsuits on kind of every measure fail the test, the most basic tests. Normally you'd have to go in and say, you company A did this and it hurt me, and they don't do that. It's like 25 leaps. And by the time they're done leaping, they're just saying the Earth's atmosphere is getting warmer, and that's having these effects. But they floated, like in our last hearing in Trenton a couple of weeks ago, that they have an attribution theory, but that's just a crude measure of how much oil and gas, for example, companies sold, and then they divide it up. That doesn't tell you anything about anything. So whether someone was harmed by something you did. So I think there's standing problems. There are all sorts of just fundamental flaws in these cases. But I think it's a pretty transparent gambit. I can't help but use that word to sort of pretend these are like tobacco cases or opioid cases, but the analogies just fall apart with any sort of look and close look. And again, the bizarre notion that Honolulu can sue for activities that it engages in itself, that it depends on for its economy to run, with respect to claims of misrepresentation about information that has been widely known by Hawaii itself. Some of the earliest research on climate change, famous research projects took place in Hawaii back in the late 50s, and that they can bring a claim based on activities happening all around the nation, all around the world, and not want to stop it because they need it for their economy and for life to go on. It really is something extraordinary that is being replicated in all these other jurisdictions. We really need the Supreme Court to weigh in and say, this cannot stand. Our constitutional structure doesn't allow it.
And what sort of relief is being requested here in these cases? Is it just money, or is it injunctive relief of some kind? Can you?
It's the kitchen sink. They disclaim we're not trying to regulate emissions, but they want compensatory damages, punitive damages, abatement damages. And I argue, I said to the judge in Trenton the other day, they want you to be the abatement czar. Like you're going to be figuring out how much it's going to cost to, put reinforcement on the shoreline or do other things in the locale. They want abatement damages, they say, so some sort of fund. They want punitive damages to punish these companies for their speech and for their alleged failure to disclose, to stop them and to regulate or to cause them to start speaking. And they sometimes suggest they want, even more, that they want some sort of injunction to force production to cease. The complaints sound like that, but then when they're in court, they sort of back away from that. But however you cut it, it's extraordinary relief that would have the real effect of both regulating speech, but also regulating emissions outside of each state in a way that clashes with our federalism in basic constitutional principles.
Next question. Does the pending cert petition in the U.S. Supreme Court potentially impact all pending state court climate change cases? I know there are California cases that have been remanded to state court. Are those there to stay?
Most of them, maybe all of them, are in state court to stay, but the issues were now, and I should make clear because it gets confusing, particularly because of the way the plaintiffs' lawyers now are seeking to rely on their removal decisions. The cases pending, our case pending now on cert is on the merits, and it's on the merits of whether state law, not applied by state courts, can be used to impose damages based on global greenhouse gas emissions. And if the court takes the case and decides it will have an immediate direct impact in every one of the pending cases, because they all are premised on the same theories. Most of them are brought by the same law firms. We do have a case in Puerto Rico that's actually has a RICO claim in it, but it's in federal court. That's got some other twists and turns, but it would still be taken off the boards if we can persuade the Supreme Court to grant cert here and look at the merits. And if we prevail, that's why we think it's such an important case. And so it's not just this case, it's the classic type of case that the Supreme Court is there to decide, one that will have widespread impact on an important issue where the courts are divided, and that it will have a huge effect on our economy and on our national security. One of the amicus briefs, several former Joint Chiefs weighed in on the national security issues here that are implicated by these lawsuits that seek to meddle with, interfere with, and constrain energy production in the United States. And so, bottom line is this would have a significant effect on all the pending cases, and that's why we think it's so important that the court take the case.
Our next question: if the Supreme Court refuses cert, what are the strongest defenses to consumer fraud claims? Have similar municipal claims failed in other litigation?
On the merits on consumer fraud, we have a lot of arguments. One, the First Amendment arguments I was mentioning, that in some instances they're challenging truthful speech. In others, they're saying it was misrepresentation, but they can't identify a single statement that, for example, Chevron made that was false. They have the problem in consumer deception cases that if they're seeking to bring consumer deception cases for speech and consumer interaction outside the state, we still have on the merits all these arguments. If the court doesn't take the case, all the arguments that I'm making today and that we've been making, it means we're going to keep making them in all these different states. We've, I think, had four or five of the motions to dismiss argued so far. That leaves, probably 30. And so we'll keep making these arguments, including on consumer deception, where you've got First Amendment arguments, you've got just the sort of statutory interpretation. Most of the consumer deception statutes are meant for what you and I would think of as a consumer deception case. I say to you, buy buy this car for me. It's got, 500 horsepower engine. You buy it and it turns out it's got 100 horsepower engine. A merchant sells a product to someone and lies to them or deceives them. And it's just not what these cases are. They're not claiming that people didn't get what they paid for. They're claiming that they got what they paid for, they used it. Others got what they paid for, they used it, and it caused this atmospheric effect that then came back and somehow had an effect on them. And so if the courts really drill down on the merits, and as I mentioned, in arguing in the various jurisdictions under state law is very helpful to us. California, where I'm based, we have statutes that affirmatively establish a policy that oil and gas production should be encouraged in a wise manner, but to the maximum extent possible. And so they're bringing claims saying, that they really counter that state policy. The state of California is bringing, they filed a suit now. So we've got, I think, very strong arguments under state law as well that should doom these cases. But the courts really shouldn't have to get there, because out of the starting gate, the lack of state power to be used to seek damages and thereby regulate interstate and international emissions cuts off these claims right there.
You had mentioned how this would represent a huge expansion of tort claims. And on other side of this issue, could we see after this tort claims, particularly if Honolulu got its way, of people who use, oil and natural gas and other fossil fuels to like heat their home and drive their cars? Could we see torts against these municipalities that are regulating fossil fuels?
I think so. I mean, I think that the claims that they're making, as I mentioned, the federal government is facing claims like this, but the claims could be brought, so I think you're suggesting, like, if the prices go up, maybe you can sue for the lawsuit being brought that caused the prices to go up, and it some sort of action. It really it unleashes all sorts of possibilities that we don't want to have realized, because there are the lawsuits that could be brought against different sectors of the economy. There are lawsuits, technically, that could be brought against the municipalities and the states themselves for some of the same things they're suing about. And then there is the fact that these governmental entities are doing things with these lawsuits that really are going to be detrimental to their citizens. So it creates this whole collateral set of possibilities for more litigation, which I don't think we need. And it doesn't solve the problem. When pressed, the plaintiffs' lawyers basically, you asked me about the remedy, they basically admit it's just about money. Like in Hawaii, during the argument, one of the justices asked the lawyer arguing on the other side if he wanted warnings, and he said no. I think he said, I don't want to quote him because I can't remember exactly what he said, but the gist of it was, no, it's basically, we just want money. And so that's not going to help slow climate change, other than their theory is the imposition of damages will change behavior of these companies and reduce oil and gas consumption and reduce emission levels. That's unconstitutional. States can't use their tort damages to do things like that intrude on the prerogatives of other states and the federal government.
Time for a couple more questions here. If there are 34 cases around the country, it seems like a big beneficiary are the trial attorneys bringing these lawsuits. Can you speak to their role in these cases? And if cert is denied, what would be the role of plaintiff's bar moving forward?
Yeah, well, it is a potential plaintiff's bar boondoggle, that they've got these cases, they're making the same arguments around the country. It's, and as I mentioned, there's, the funding is coming from foundations there. To my mind, there are real serious problems where they're also linking up with governmental entities. So they're sort of getting the benefits of being a governmental entity. For example, some states, the statute of limitations doesn't apply to the state. Mm-hmm. So the private lawyers, and again, I commend them for their creativity and entrepreneurial skill, but it is weird when we're all flying around the country to these cases to talk about how there should be less fossil fuel consumption. It's ironic. And so I think, that there's going to be more and more litigation, and more plaintiff side lawyers will be attracted to it if it looks like it's just going to go on, and there could be some reward at the end. I think some of them are being compensated, now, but there are some, I'm sure, on contingency fee arrangements. So in addition to everything else, it's sort of a tort tort reform. I think the American Tort Reform Association filed an amicus brief in support of this, but it's a tort reform lawsuit nightmare of the kind we will never have seen. It's everywhere, everything, all at once in litigation, and none of it is allowed by the Constitution. It's just beyond the scope of state power to even be embroiled in this in the first place.
And
that kind of goes to your question about what is the state doing paying these private lawyers? They have lawyers. They've got, the state of California has excellent people who work at the Attorney General's office. So I'll leave it there.
One last question. When and how do you imagine this litigation concluding? As you mentioned, it has been proceeding for many years, but it doesn't appear that a conclusory adjudication or settlement is coming soon. What do you predict?
This round, I mean, it's wild. So I mentioned I was involved in that GM case. That's going on 20 years ago. And here we are in 2024. The first round of these cases were the state court, state law cases. First batch was filed in 2017. We think the first potential resolution comes with the Supreme Court granting cert in this case that's pending, finding that Hawaii was wrong, that state law cannot be used to allow damage awards or any other relief based on global emissions. That, I think, would effectively end all of these cases. In Delaware, it's a great question, because in Delaware, as I mentioned, the trial judge said all claims based on out-of-state emissions are dismissed because state law cannot be used. The Clean Air Act preempts them, and it's beyond state power. The court relied on the city of New York. And the Delaware then went to the Delaware Supreme Court saying, this basically guts our case. It ends our case. And so if other courts even just go that far, because the trial judge didn't dismiss all the claims, but they were narrowed down to, in-state type claims that will fail, because the whole theory of the complaint is that it's the global out-of-state emissions that caused their harm. So we're very hopeful the Supreme Court will take this case. It's important. There's a square conflict. It's recurring. It's recurring right now. It's got all the features that support cert. It's incredibly, it will have a widespread effect if the court rules on these issues. And that's why we think it's just the classic case for the Supreme Court review.
Any closing thoughts before we end the program today?
I'll finish with this. First, thanks for having us and having me. And as I said, our position has been, since the first set of cases was filed in 2017, is that climate change is an important issue. We need to grapple with it from a policy perspective. But lawsuits are not the road to do it. The Supreme Court and AEP said that, and the federal system, and if federal judges aren't equipped to do it, where it's an inherently federal area, where uniquely federal interests require federal rules, then how can it possibly be that dozens and dozens of state court judges can be in the business of creating torts that are meant to affect and regulate emissions and thereby address climate change? It just doesn't hang together. And we're hoping the Supreme Court takes the case and makes that very clear.
Well, thank you so much, Ted. And on behalf of the Federalist Society and the In-House Counsel Network, I would like to thank you for the benefit of your valuable time and expertise today. And I would like to thank our audience for joining and for participating with those great questions. We welcome all listener feedback by email at info@fed-soc.org. And as always, please keep an eye on our website and your emails for announcements about upcoming webinars and other events, including our In-House Counsel Network Conference, which will be held in Dallas on May 17th of this year. So registration is open. Thank you all for joining us today. We are adjourned.